So here is what we thought we would do. We're going to ask some questions. At some point, as I've explained before, Justice Sotomayor may walk around a little bit, which causes the Secret Service and her marshals no end of grief and aggravation, which is, I always felt a little aggravation, good for the soul. But that means that if all of you will stay seated from this point on, I would very much appreciate it.
They'll appreciate it more.
Well, I hate it when I have to tackle my own people. It's really... Although there have been moments when we felt like we've had a combat sport, but today is not one of them. So let me begin. We have some questions.
Can I say hello to all the old friends I see in the audience?
Yes.
I can't mention all of you by name, but everyone who knows me personally knows who you are. And thank you for being a part of the ALI, because it's such an important organization in the development of sound law, and for your presence here today. So at any rate, please.
And we have clerks here, I think.
I know.
So all of Justice Sotomayor's clerks will let you stand up. So we can say welcome and we know where you are. I can't see you, but
I don't see them,
I know you're
but
here. So
my clerks are not shy.
Yeah. I'm surprised to hear that. Your path to the Supreme Court is wonderfully described, actually, to the bench, not to the court, in your book. Can you reflect for us a little bit about the risks that you've taken, and also some of your mentors, or people maybe mentors you wished you had had, and what impact those things in your life have had as you became a justice of our highest court?
At least one of my mentors is here, and one who has been an example to me throughout my legal career, Judge Jose Cabranes of the Second Circuit. And the other you'll see tomorrow, Justice Stevens. And when one talks about mentors and their impact on you, you can't really talk about, do I sit there at conference or as I'm preparing for conference and think of what a particular mentor would say to me. Because that's not quite how the enterprise works. You sort of work through a problem and you come to an answer and you test it against what your colleagues are saying and against and with your colleagues and come to your decision of what you think the right answer is. It actually takes a certain kind of courage to stay true to that right answer, especially when you're dealing on a collegial court, and by that I mean a court of more than one. All right. It was very, very easy, relatively speaking, as a district court judge, to sort of come to an answer and do the best I could and come to your judgment and announce it. And you might on occasion understand the judgment might not be popular, but thankfully the forefathers gave us a job for life to ensure that that didn't completely influence us. But it is much harder to stay true on a collegial court when you're dealing with more than one person, because you have independent pressures, and that includes the pressures of having two colleagues whom you respect, potentially disagree with you, and try to convince you that if you're not wrong, that there's a better way of doing things. And almost always there's an appeal to the institutional interest of it's better for the court as an institution to have unanimity. It gets even harder when you're a group of 9. The pressures are greater, and so is the sense of obligation to work together, not just on this case, but in the future. The one thing about the two mentors, particular mentors I mentioned, and I don't mention the ones that mentored me before being on the bench because I describe them in my book. And so I'm going to send you to my book if you haven't read it, okay? And as I tell people who write me now, the public library has it, okay? But putting that aside, when the two mentors I have really set a very high example for me of being collegial, but at the same time principled about the positions they took. Even when they were not necessarily popular or they weren't necessarily consonant with the views of the majority, they've stayed strong to those principles. And in many ways, it's whom I've tried to emulate, both of them. Judge Cabranes, Jose as a friend, and Justice Stevens really taught me the value of not being afraid of being a sole voice when you think it's important to be one. It's a fine balance between trying to find that place where it is important to be collegial and when it might be important, but a greater principle is at stake, and you have to speak out by yourself. I remember Justice Stevens at one point saying to me, Sonia, I list cases on our cert petition pool just so that we talk about them. And I'm not afraid of being the only one who votes to grant, because sometimes the purpose of conversation has importance in and of itself, regardless of the outcome. And those messages have stayed with me.
Well, that's very helpful to all of us. We pride ourselves as an institution, Justice, on being able to have strong feelings on many sides of an argument, but especially in this world outside this room, we manage to maintain great civility and respect for one another, and it's wonderful to hear that that exists at our highest court in every way as well.
Well, personally, there's really no question. I remember coming to the court thinking to myself, is this a charade? Because you hear all the justices and public occasions talk about the collegiality that we have amongst each other. It's not a charade. It's very, very genuine. I wish our opinions would reflect that. However, and this is an explanation that I give whenever I'm questioned about it. Every one of my colleagues is passionate about the same thing. We're all passionate about the Constitution, and we're all passionate about our system of government, and we're all passionate about the rule of law. We obviously disagree, not infrequently, on what the right answer is, but that disagreement and how we express it in our writing is very much a product of that passion, of that deep belief that we need to get things right. And as I remind people, when you read our opinions, you'll notice that the most passionate ones are usually the dissenters. And that's for obvious reasons, because you want to shake your colleagues and try to get them to see their erroneous ways. I'm quoting now from Justice Kennedy and one conversation that I had with him around this very topic. But that doesn't need to translate into your personal relationships. And we manage to ensure that it doesn't.
Thank you. You mentioned the certiorari process, which is a total mystery to most of the lay public. But even an audience like this of legal scholars and judges and lawyers have questions about the cert process. And I wonder, for example, what do you hope is the impact of a dissent from a denial of certiorari?
As with all things, including dissents themselves generally, there are always different purposes to dissents from denial of certiorari. In some cases, it involves a justice with a view that the lower courts are consistently getting something potentially wrong. And the continuous denial of cert might suggest that they're right, when not infrequently, prior dissents may have been based on procedural hurdles or because they were involved with other questions that the court wasn't prepared to take on at that moment. And so sometimes the denial is a conversation between the court and the lower courts about looking at whatever is being discussed and not robotically applying whatever precedent seems to be existing down there. Occasionally, it's a justice's statement about what he or she believes is a wrong turn in the law or a prior wrong precedent, and that justice is trying to convince the other justices that it's time to take up the question. And clearly you know that when you do that type of statement, that lawyers are very quick and will start promoting that idea in the courts below and eventually bringing to the court that question more starkly so that the court can then actually, as a court, decide whether it's something that it wants to deal with. And sometimes, and some, are just statements about what seems unfair or wrong to a sitting justice, about a process or a procedure that's happened below, that the justices vote to join a denial or to dissent from it is attempting to voice. So you can't attribute one reason to a statement from the denial of certiorari. There are generally different purposes to each denial, and you just have to look at the circumstances, and most of them will explain to you what the purpose is. You know, I've done, as you know, a few of them. I did follow the precedent of my mentor, Justice Stevens, who did quite a few of them himself, and I think that they have value for the purposes that I've described.
Thank you. You spend a great deal of time, which makes me happy because you're such a great ambassador for the American justice system, talking to lay people and talking to students.
I'm going to walk around now.
Okay. And I wonder, what do they ask you about the court or the legal system or your career that we should do in order to, that we should know in order to do our work better?
Oh, how interesting. Most lay people have no idea what lawyers and judges do. Sounds strange, doesn't it? But when you think about it, we live in our world, and so it seems to us that everybody knows what we do. And the reality is that most lay people don't. I get simple questions, especially from students, but I get them from adult groups as well, as to how come there's so many courts? They have no understanding of the levels of courts. More routinely than not, they have no understanding about what appellate review is. It's a total confusion in their mind. Quite often they think that we deal with juries as well. You think that this is the sorts of audiences that I'm going to, because I do go very often to lay audiences, but it's not. It's middle school, high school, college students. I go to adult groups of all kinds. I've spoken to medical students, non-lawyer groups, so you understand that this is more common than thought of. The second questions are not dissimilar from the ones you just asked. Why is it that the law is not clear?
We just had a big debate about that.
Yeah. And I'm very fond of telling them that the law is the gray area, and very truthfully saying to them, you wouldn't need us if the law was written as clearly as people would hope. But the problem is you can't write laws that way, because legislatures are responding to a problem that they're trying to fix. But no matter what the language they use in trying to capture the breadth of their problem is also going to create the confusion of the problem. And the confusion is going to happen in the very next case where the facts are slightly different. and we incrementally try to answer each step by step of what falls within the law and outside of it. But I think mostly they want to know why we're important, which is a strange way to say this or ask that question. But it's one of the reasons I do go talk to lay audiences. And I talk also to lawyer groups. Here I am, okay? But I do think it's very, very important for all of us to understand that we have to educate people about the importance of law in their personal lives. Most people forget that the simple things they do are affected by law. My favorite conversation with students is, walk out the door of your house, go to the corner, and when you stop at the red light, why are you doing it? And some will say, because it's a safe thing to do. And I'll say, yes, but what happens if you don't? What have you done? You've broken the law. Then they'll look at me, I'll look at them and say, that breaking of the law seems wrong to you, because you intuitively understand that what the law is trying to do is to find a compromise between our desires to get where we're going as fast as we can, and society's need to ensure that most people get to where they're going safely. So what the law is asking you to do, you agree with. It's asking you to give up a little bit of time so that the greater good is served and more people get to where they're going safely. The problem with most laws that people are disagreeing with is that they don't like the trade-off. They're unhappy with what they're experiencing, right? But if you can get them to understand the purpose of law, I have found, they're much more willing to engage the conversation about both the process of lawmaking and law interpreting and the work of us as lawyers and judge. But I think is that most people don't understand that basic function of law, which in my judgment is defining relationships, helping create them, helping them function better, which to me is what we should be doing as lawyers, period. That's what you're doing in this organization. You're trying to make sure that the law is explicated in a way that people can more easily understand it. That's about our relationships. Business relationships, relationships among and between people in government, people in institutions. And I think that that's really what the interest of most of these lay audiences is.
Thank you. Many of the cases that come before the court have profound and broad social impact. How do your personal experiences affect your consideration of these issues?
You know, I'm asked that question all of the time. And it's very hard to describe that because obviously I don't go into a case and say, gee, this is an important case and it's going to affect this group of people negatively, so this is the way I'm going to rule, the opposite way. I don't know of any judge who does that, okay? And it's a very bad thing to do anyway, for the very reason I explained earlier, which is since laws and life is about competing interests, I can't presume that my view of what's right is the greater life view. And it certainly may not be society's view. And so I'm very cognizant that my personal knowledge or feelings can't compel the outcome of whatever decision I make. Does it help inform my knowledge of what the issues are and how they may impact people? Absolutely. But that's what those countless amici briefs do. You guys file them all the time? And what are you trying to do? You're trying to tell people exactly what I'm talking about. how this decision will affect your client and how that effect is different than what we may know about or not know about. So it's a bit of an advantage when you've lived that life, have had that experience, that you don't have to look at the amici's brief to understand it. That's a help. But I think more information rather than less about how your decisions impact the larger society, I think is a benefit to any decision-making process. And so, to me, sort of my world experience is perhaps a little different than my colleagues, but I think it's an important voice to have in the room. One, to be able to discuss these things and sometimes convince and sometimes not convince. The reality is, the wonderful part about being a justice, we can write dissents.
Thank you. So let me ask you a question. These days, one of the things that's much more available to all of us and to the whole public are the oral arguments. With the internet, it's easy for us to listen to what goes on, listen to the lawyers on both sides speak, and also listen to the questions. Can you talk a little bit about what role oral arguments play for you in coming to your decisions about matters?
That's a veiled other question. How often do oral arguments make a difference? And it's not like I keep a scorecard. So all of no one can tell you makes a difference in 5, 10, 15, 20%. What I can tell you the difference it makes most generally is in the process. We spend our time listening to each other's questions. Now, you say, you're not listening to me, I'm the lawyer up there arguing. If you haven't made your best argument, gosh, these are all old friends. If you haven't made your best argument in your papers, you've lost the case. Remember the forfeiture rule? If the argument's not in your papers, we're not going to rely on it. We don't rely on it if an amici brings it up and you don't, unless you incorporate the amici's argument by reference or otherwise, okay? But my point is that we have read your papers. Everyone here knows that the Supreme Court is a hot bench. And it's because we know your arguments, our questions have a different purpose. First, in part, to educate ourselves. It's something that the justice asking the question is truly unsure about and doesn't have their own answer. Sometimes our questions are to satisfy us that the decision we're thinking about is the right one. And sometimes it's to try to get an answer to something that's troubling us and can affect the outcome of our vote. But often it's a conversation among us. It's our first time we're sitting together talking about the case. And in that situation, it's very, very important for me to know before I vote what my colleagues are thinking. What's troubling them? Do I have an answer? And I hope it's better than the one the lawyers gave. Truly, if I believe in your position and you've given an answer that I see is not satisfying one of my colleagues, I have to sit down and analyze that and figure out how to present my vote in a way that might persuade one of them to change their minds. But this conversation is one that informs our ultimate vote that we have 2 days after the argument. For those of you who don't know, on Monday we hear a case. If we sit on Wednesday, we vote on the Monday cases. For the Tuesday and Wednesday cases, we vote on Friday morning. And so we always have 2 days to digest what has been going on in argument and to figure out how it influences our final vote. And so for me, oral argument's terribly important for all of the reasons I explained, both to answer my questions, but also to inform me of what my colleagues are thinking. Does it make a difference? It does. Can I predict in what cases? No. You don't want to be the one that we don't hear if a justice has some doubt. So whether it's important in every single case or not, I can't say that. But it is important enough to the process of decision-making that I think it's worthwhile.
Thank you very much. You alluded to this in your last answer. You've had a long career before you went on the bench in which you were an advocate. You were an advocate for the public as a prosecutor. You had clients. Do you find that your advocacy skills kick in when you walk into that room and try to persuade your fellows to come to your point of view? Do you feel, again, like a lawyer with a client in front of a judge of other people?
Much more than I ever did as a trial judge or a court of appeals judge. Conversation was much more free-flowing and much more give and take in the Court of Appeals than it can be on the Supreme Court. There's 9 of us. And that does constrain you to be as succinct and precise as you humanly can when you're making your presentation of your vote, because you have just a few minutes to make the most convincing part of your argument and to get the group thinking about what you're saying. This chief, I understand, unlike the predecessor chief, and I wasn't around for this, so I'm relying on what I was told. With our predecessor chief, you got only the moments that you had to articulate your vote and had to be very quick. This chief will let conversation continue among the group if things are being said that obviously spark interest and/or concern or some sort of group conversation. It doesn't go on forever, but that presentation does require you to be a skilled lawyer.
Well, we're glad that you had that early training then. You talked about what happens when lawyers either answer or don't answer properly in oral argument. The American Law Institute is all about the written word, and the exact words are important to all of us. If there have been some briefs that have caught your particular attention or helped guide your thinking in a particular case, can you tell us what were their common attributes so that we can all improve not only our now oral argument skills, but those of us that are writing those briefs that you see?
Don't repeat the obvious. I can't believe how many briefs come to us repeating arguments that have been made repeatedly in the decisions below. We read those, okay? Arguments that others are making in amici briefs or otherwise. The briefs that are most compelling are the ones that offer a view, a position, a perspective that's not the norm. And so, for example, I've written one concurrence in a, of all things, tax case, PLI versus the IRS, which was based solely on the thoughts of a concurrence, and I acknowledged it in the concurrence. It was an argument that the parties had not made, that the government disavowed, but which I thought was stronger than the arguments being raised. When I was on the Court of Appeals, can't be so direct as to name the case because I ended up not voting on the case. But I was sitting on a very complicated case where I had a perspective that wasn't being discussed by the parties, and I didn't know whether it had legs or not. And I went to look for law review articles, of all things. And And I found one that actually was talking right at what I had come to decide. If you're going to do an amicus brief, if you're going to do a brief, think about talking about a perspective that's outside just your client's interest. I know that seems a contradiction in terms, doesn't it? But you have to remember that when we're ruling, we're not ruling in favor of your particular client or against your particular client. We're ruling for or in favor of a particular legal way of looking at a problem. And so for us, what we appreciate are briefs, are amici briefs, law review articles, who help us think more broadly about the legal issue that's before us and how it will impact other cases and how we should approach it in a way that will help guide lower courts and parties to come to what should be, I hope, the right answer. And that's a little harder for some people to do as lawyers than others. There are, and maybe that's why the Supreme Court bar is generally more skilled at it, because they've spent more time doing it. But when you read their briefs, they're really talking about not their client's position, but about the history of that legal problem and how whatever answer we give should take account of the broader legal perspective. And those really are the best briefs, the ones that help us come to recognize what the correct answer should be in that way.
Thank you. Now let me go to some questions that have come from our members to you, and Ricky will give you an opportunity to hear some of our members' direct concerns or questions. Ricky?
Great. Thank you very much for agreeing to answer questions from the floor. So the first question I'm looking at says...
I don't think you're censoring either, except by not asking the question. How's that?
So the first question says the ABA, the White House, the Department of Justice, and the Conference of State Court Chief Justices have all taken up the issue of improving access to justice for the huge number of unrepresented low-income litigants in America's courts. Could you share with us your views on how to deal with this issue?
Well, I'm probably outside the norm. I believe in forced labor. Involuntary servitude. Now, and by that I mean, if I had my way, I would make pro bono service a requirement, which it is, I understand, in New York State now, but it is not in the majority of jurisdictions. And I understand the negatives that affect that decision, including the thought that if you force someone to do something, they're unlikely to give it their best effort. But I rely on the ethical, professional sense of people, and of them, or the vast majority of them, understanding whether they want to or not, that once they're obligated to render service, they should render it properly. And in those regards, thank God for malpractice. So there are some safeguards against it. But I do think that we don't do enough in law schools. Ricky, you, more than anyone else when you were dean, probably heard me on more than one occasion talking about the importance to inculcate in law students the obligation of public service and pro bono service. And I talk about it constantly in virtually every law school I visit, because we need to have young lawyers graduating with that sense of being a part of an honorable profession devoted to serving others, with or without money. We are one of the few professions where the ABA holds it out as an ethical standard. Think of doctors, the Hippocratic Oath. Do no harm, but it doesn't say don't charge. All right? Ours at least says don't charge. And so I'm not sure, Ricky, that any program that's instituted, including the New York State one, will fail unless we have brought to people's attention, that our young lawyers, the necessity of doing service. It has to become a part of their being. All of the wonderful lawyers in this room, you're here because somewhere, somehow, that became important to you. And we have to find out what that elixir is to feed our young lawyers and promote their thinking about how important it is to serve. And to serve particularly the needy. Because if we don't, then, you know, there's a lot of talk about money in politics. There's a lot of money in law. And if we think it's wrong in one venue, it's equally wrong in another, especially when we're talking about justice. And so for me, I don't have an easy answer, but I have one that I consistently try to preach, which is we have to serve, and we have to serve all people in our society. And as you all know, I worked in a private law firm with some very rich clients. So I don't think that the rich shouldn't be well represented. I just think everybody should be well represented.
Thank you. Thank you. You already addressed one part of the question, but the question is broader, so I will go ahead and ask it. It says, what has surprised you, for good or ill, about the differences in internal institutional dynamics between the Supreme Court and the Second Circuit?
You know, it's much easier to deal in a group of 3 than 9. It's so much harder. And it's much easier to peel off one vote. There's a group dynamic. And if you're part of a group, there's a group. I mean, there's tons of psychological studies that are done on decision making that show this, that when you're part of a group, it's very hard to get dissenters from that particular group. There is a security blanket in numbers that works to the disadvantage of being able to convince each other, I think. It was a much more fluid conversation on when there's only 3 of you talking. And the ability to find a compromise that satisfies 3 is a lot easier than finding a compromise that satisfies 5, 6, or 9 in particular. And so I think that has surprised me the most. Personally, and I've spoken about this in other fora, I, having been a judge for 17 years before I became a Supreme Court justice, and even now, it's almost 25, shocking, isn't it? I thought coming to the bench that I had the decision-making process down pretty well. But I had not anticipated how comforting it was to me as a district court judge and circuit court judge to have a court above me. You know, after I had worked as hard as I could to come to the decision I did below, and especially in those hard cases where you might be sure, but maybe you're not 1,000% sure, okay? You're 999% sure. It was so much easier to finally say, stop, I'm going to rule, because if I'm wrong, or even if I'm right, there's a court above me that'll take responsibility. That doesn't happen now. And I had not anticipated how much more difficult the burden of decision-making is on the Supreme Court. Even, look, we're all fabulous, fabulous lawyers and writers, and you read our opinions, and you wonder, how did that court below make that mistake? All right? Or you read a majority opinion and a dissenting opinion, and you pick one side and you say, they're clearly right, or they're clearly wrong, whatever you say, but it seems clear to you. But when we're reaching our decisions, you got to remember, there's a circuit split. Other reasonable jurists have disagreed. And as a result, those jurists didn't disagree because they're unintelligent or unthoughtful. They've disagreed because each of our decisions has a counter-argument. And coming to what the right answer is, at least for the court at that moment, is harder than I ever imagined, even in our decisions that are 9-0. I often tell law students, look at the arguments we swat away in footnotes. Go do a little investigation, and you'll see often how those arguments were the most vexing for the courts below. And we have the luxury of swatting them away, but they couldn't. And so I think those are probably the two institutional lessons that I had not anticipated or really understood fully.
Thank you. The next question is related, and it is, what have you found to be your greatest challenge as a Supreme Court justice?
Thank you. Repeat the question. I got distracted.
So, it's, what have you found to be your greatest challenge as a Supreme Court justice?
Well, I've just talked about the challenge of ruling, but I'll talk about a different challenge, which will seem strange because it's not legal, but it is. Who do I say yes to in the thousands of invitations I get? And you're all laughing, but as Ricky and I were walking in, I looked at Ricky and he was talking about who got Justice Stevens to come tomorrow. He got me to come here. It does help when you reach out to a personal friend. However, that also makes it more difficult for us to say no, but we have to sometimes. There are so many groups who want to hear from justices and who want to meet us when you come in for bar admissions. We get them every single day of the year. I will say that some of this I've brought on myself because of my book. I probably get invitations from people who may never have thought of inviting a justice, but it tells you how great the need is out there for groups to have speakers who will talk to them about the law. And I don't think that it's just us justices who are obligated to do that. I know that many of my colleagues, judges on the lower courts, do it regularly. There's a whole bunch of them here right now. But we need all to reach out more broadly. We need to go to those grammar schools and those colleges and those high schools and the nursing homes. I get invitations from those too. To the book clubs, to the American Legions, to all of the different people who have an interest but don't know who they can reach out to help them satisfy that interest. And so that's something that I've spent a lot of time sort of thinking about my own priorities and how I organize the little free time I have. The least favorite letter you'll have is the one that says, I can't do this, otherwise I sacrifice my court work. But in fact, that's true. If I did everything I was invited to do, I would never work. At least not work in the court, anyway. But for myself, my most important mission is education. And to the extent that the audience that I'm speaking to is involved in education, that means there's a greater likelihood that I will say yes to an invitation. If it involves work with younger people and educating them, I will do it. If it involves educating more senior people, I will do it. If it involves policy questions about education, where I'm just being asked to talk about the things I know, the things I've experienced, I will do that. For personal reasons, my own diabetes, I do, as a subsidiary issue, do things related to health questions, but I can't do all of that. That takes a second tier of importance. I balance what I do in terms of education. So, if I go speak to a prosecutor's group, I find a defense group shortly thereafter to talk to. If I find a plaintiff's groups on employment law or something like that, I'll find a defense group to go talk to. So if you make it easy for me and you involve both sides, I'm more likely to say yes, okay? I'm very careful about balancing the schools I go to. And so, I have an Ivy League background, and as a result, I have very many close friends at many of the Ivy League schools, including friends like Ricky Rivez. And I do many of their functions. But this was a lesson taught to me by my colleague, Justice Thomas, who, in one of our very earlier conversations before I was a justice, during a moot court at a local school in New York, he does ask questions at moot court. Which was a pleasant surprise for me. But he said that he doesn't believe, I think he's changing his mind about this, he's now doing a lot more of it, but he didn't believe in going to the Ivy League schools because all the other justices went regularly to them. He wanted to go to second and third tier law schools because there the kids were working harder. And many of them believed more strongly in the power of an education in law. Whether he's right or not about that, it made me very sensitive to ensure that I went to as many varied types of tiered schools, so I wasn't devoted to just one kind of school. I go to public and private schools for the same reason. And so I guess it doesn't seem like much of a problem to you, but given how limited my time is and how precious it is, being able to articulate for myself a set of priorities makes it easier to say yay or nay. Now, almost any group you talk to who you say no to will tell you how big a mistake you're making. And they're probably right. But as I just said, choices have to be made, so you make them as best as you can.
Well, I hope you know how much we appreciate the fact that you are here talking to us today. But I also hope that because our mission is to clarify and improve the law, you won't now feel an obligation to talk to a group whose mission is to make the law less clear and worse.
I talk to judges all the time.
Oh, yeah. Thanks for being here.
That was a joke.
So, I assume you've heard and talked about this question before, but there are people in this group that are interested in it. And the question is, do you think the Supreme Court will eventually permit video recordings of oral arguments?
Well, I will say the following. Justice Souter is no more there. He's still alive, so we won't have to walk over his dead body anymore. I think it's a conversation that's going to be difficult to get unanimity on the court about. And it's much more complex a question than I thought before I became a justice. And some of the reasons for my own change of views, or I shouldn't say change of views, but greater hesitation than before, have been born during my confirmation process. When I learned, having spent, I think it was 92 interviews with senators, that many of them felt that much of the collegiality, lack of collegiality in the Senate and in the House occurred when television cameras came into the chambers. Especially the senators with experience during those times would tell me that when people were forced to be in the room, they were forced to talk. It was much easier to grab somebody's elbow and pull them to the side of the room and convince them about something than it is now, where they're not listening to each other. I can't tell you how many senators I interviewed with while there were debates going on the Senate floor. The debates weren't even on the television in their room. Some staffer was watching, but how much information they got, I suspect very little. They got broad painted pictures, strokes about what the debate might be about. But the impact of what people see on television, you know, what was it, Senator D'Amato, with that pig thing that he did once? Public saw it, public enjoyed it, but did anybody else that he wanted to hear it, did they? I'm very doubtful. And so that experience made me hesitate about cameras in the courtroom for the following reason. No matter how hard you try, a camera in the courtroom becomes the center of your mental background. How you say things, whether something that you're just thinking spontaneously comes out or not, will be played against how foolish will I look on television tonight. It's one thing for the press to report on what happened before the court or to take an oral snippet, and a very different thing than to play a picture of someone saying something. The impact is dramatically different. And to the extent that a camera in the courtroom could make some justices more reticent to speak, or that might encourage other justices to speak more, I don't know which one it'll be. And I worry about that. I do think it will ultimately change the dialogue the court is now willing to have. You come in at our hot bench, and we are really talking to each other. I have a fear and a concern that cameras in the courtroom will mean that we're talking more to the camera. And that's something we should worry about, because there is a process of deliberation that includes the oral arguments in a way that a camera would impede. So.
Thank you. And I'll ask one last.
Did I step on something? I'm not moving.
Okay.
No, I didn't step on anything, so it wasn't me. I thought I did.
That might be true, but I have a clot in my coronary artery.
So I'll ask one last question from the floor, and that is, to end on a lighthearted note, it's, what do you do for fun?
What do I do for fun? I love bike riding. I haven't done enough of it in the last year. I hadn't done enough of it in 5 years, and about 2-3 years ago, I went out and bought a bike for DC. And I've gone around many of the local trails, which are beautiful. The trails in Washington, Virginia, and Maryland are quite unlike those in New York. I think positively and negatively, okay? The trails in New York that are paved have less holes in them than in this area, okay? You know, it's a difference in where money is spent and what's done. But there are more isolated areas from cars in this region than there are in New York. And so I love bike riding. I actually, although lately it seems I haven't gotten enough of it, love exercising generally. And so I do have a trainer. And I don't know why it's a thing that the women on the Supreme Court do. But my male colleagues, some of them do exercise in the gym, but I'm not sure any of them have personal trainers. But the women do. The women in the group can speak to that, okay? I, for one, love playing poker with friends. Yes, I do fleece them. Or that's what they will claim. Some of you will know from my book that my father loved math and had a great facility for math. I'm not anywhere near close to what he was, but I am not afraid of math, and I love the strategy and the calculations of poker. So it's distracting and fun for me. And no decision I make there is fatal. I don't bet enough for it to be fatal. And I love cooking and having dinner with close friends. I'm doing less cooking. I try to go out more because I just don't have the time to cook as often, but I try.
Thank you. Roberta will close this wonderful session formally, but I want to say, having admired you for so long, how much it meant to me that you chose to come and address this annual meeting of the American Law Institute. Thank you so very, very much, Justice Sotomayor.
Thank you, Ricky. My mother would let me do that. Thank you very much.
Thank you so much.
Thank you.
That was super terrific. Thank you so much. It was really wonderful.
Thank you.
Super terrific.